Hello, I'm Catherine Gannon, founder and managing partner of Gannon's. We're a specialist boutique law firm focused exclusively on small and medium-sized businesses, providing all the basic law they need: contract review, directors, shareholders, articles, and reorganisations, which are increasingly popular means of planning for sale or investment. Restructuring's got a number of uses and a number of interpretations. It can mean taking a business that might have, for example, two business streams, recruitment and recruitment IT, realising it's the IT side that's going to prosper, or investors want to invest only in the IT side, or buyers only want to buy only the IT side. What do you do? How do you divide that business into two so that you can expand on the profitable business line? That's a typical reason for a restructure. We also deal with restructures where there's family disputes. For example, there might be property companies with lots of properties, and you might want to attribute some properties to shareholder group A and other properties to shareholder group B. And your problem there is if you just transfer the properties, you're going to incur stamp duty. So often you need to go through a restructuring to try and minimise your costs. Other examples are warring shareholders, where they want to split the business in order to move on amicably. Investors, they often demanding a restructure before they'll invest because they don't want their money swallowed up in less profitable business lines. So we are seeing a lot of different reasons for restructuring, and it can mean a lot of different things. It's very, very reliant on tax, because at the end of the day, you're taking one business and dividing it into two or more businesses, trying to do so in a way that means the shareholders don't pay capital gains tax, which they're at risk of paying, because when you think about it, you've got to transfer some shares in order to create two businesses. But planned properly, structured properly, you can achieve a lot of these reorganisations tax neutrally. Definitely, because the investors often only interested in part of the business, and they're not going to put their money into a company where it could get swallowed up by loss-leading business activities or by personnel and managers which aren't going to generate future profits for the business. Also, investors have got an eye on how's this business going to be sold. So, for example, we've dealt with businesses that have got factories and business premises and good trades, and the investors don't want the factories because they don't want to be part of a property business. They want to just invest in the trade. So in that type of case, in order to refinance, you may well have to reorganise how you run your business and put in place group structures. Restructuring in that context often means avoiding liquidation, so it might mean selling off profitable arms of the business. It might mean selling off subsidiaries that have got some value. You mustn't defraud creditors. So if you're doing your restructuring to avoid potential liquidation, it's really important that you take your advice in good time and put in place these structures within a reasonable period of time before the business does collapse, because if you don't, the liquidator can trace back to the directors and ask for money back, and shareholders. IP can often be put into another subsidiary. It's called ringfencing. And the reason you might want to separate out the IP from the trading business is if the trading business did fail, but you've got your IP in another company, that other company, if it's separate, would survive. So yes, putting your IP into a specialist company is very popular. It used to be more popular to put that IP company in a foreign jurisdiction, but changes in the way dividends and royalties are now treated, that's less popular tax planning. But for some companies, that's still an option to consider and think about. A demerger is where you may have an existing group of companies. One, coming back to my recruitment business, one might be recruiting people, one might be developing the IP, and you're selling the IP business. It has to leave the group because a buyer comes along. It doesn't want to buy the recruitment business, it only wants to buy the IP business. So it demerges, i.e. leaves that group and goes into the hands of the buyer. We do a lot of that type of work. Again, there's a lot of tax legislation that you've got to work through to make sure that you're not unwittingly falling into great big tax dens, because it's a disposal at the end of the day of an asset. Advance clearance one can get from the Inland Revenue. In a nutshell, the clearance will say this isn't being done for tax avoidance. You've got to set your stall out, you've got to explain to the revenue what you're doing and why you're doing it. And if you satisfy the tests, they will issue a statement saying, although you're separating your businesses, although you're transferring shares around the group, although you're creating groups and creating new businesses, this does not mean that you're avoiding tax. We get a lot of tax clearances. I'd always recommend you go down that route. It's comfort for the taxpayers. The usual taxes we're looking at are income tax, capital gains tax, and if there's property, stamp duty, land tax, that's a big tax, that can be at 5%, and of course stamp duty. So there's quite a few taxes involved. It is very specialist.